Solicitors Regulation Authority. What happens when lawyers break the rules? What are the SRA principles? There are 7 principles that all of the SRA regulated persons and law firms must meet. Principle 1. They must act in a way that upholds the constitutional principle of the rule of law and the proper administration of justice. Principle 2. Act in a way that upholds public trust and confidence in the solicitor's profession and in legal services provided by authorised persons. Principles 3, 4 and 5. Act with independence, act with honesty, and act with integrity. Principles 6 and 7. Act in a way that encourages equality, diversity and inclusion. Act in the best interests of each client. What are the SRA codes of conduct? There are 2 codes which outline the required professional standards. The Code for Solicitors and for SRA regulated lawyers from overseas. The code sets the requirements and behaviours that these lawyers must meet. The second Code of Conduct is for firms the SRA regulate. It sets out requirements for those firms, employees and people who manage them. Will the SRA always take enforcement action? In many cases, the SRA will work with a firm or individual lawyer to improve their service. In some cases, supervision is insufficient from the outset and enforcement is the only option. In what circumstances will the SRA take enforcement action? Where there's a failure to cooperate or where there are significant risks to consumers, the public or the reputation of the profession. Which factors will the SRA consider when deciding whether to take enforcement action? How many clients were affected and what was the impact upon them? Was there an impact on public confidence? Were there any patterns of negative behaviour? Did the conduct continue for an unreasonable period, taking account of its seriousness? What was the potential for impact upon a vulnerable person or child? Was there any potential to affect a substantial, high-value or high-profile matter? What is the previous regulatory history of the individual or firm, and is there any evidence of deliberate intent, recklessness or dishonesty? What kind of sanctions can the SRA impose without sending a case to the Solicitors Disciplinary Tribunal? In terms of SRA control options, they can issue a warning, a control order, employment restriction, removal of a firm's permissions, or ultimately intervention and closure of the firm. The maximum financial penalty for individuals and traditional law firms is £2,000. The maximum financial penalty for individuals in an alternative business structure is £50 million. The maximum financial penalty for the ABS entity itself is £250 million. The SRA can also issue a rebuke to the firm and/or the individual. They can issue a reprimand or severe reprimand for breaches relating to misconduct prior to the 1st of June 2010. Where misconduct is agreed, the SRA can sometimes offer a regulatory settlement agreement comprising of, for example, a fine, rebuke, making changes, an apology or a refund of money. Will the SRA send a case to the Solicitors Disciplinary Tribunal? Essentially, this is a 3-part decision. Is it serious enough by reference to the enforcement strategy and when considering the tribunal's extra powers? Is there a real prospect of the tribunal making an order in respect of the allegation, and is it in the public interest to make the application? The detailed factors to consider in a referral to the tribunal will be the subject of a separate presentation. Please feel free to get in touch if you need more information. Thank you for watching.